Do you intend to make binding instructions as to whom will inherit your estate? Are you aware that you are not completely free to do so? Then this video is for you to add legal clarity before disposing legally of your property in a last will and testament, so that you will be remembered well. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich, Switzerland. If you like this video, please forward it to someone else. The Swiss Code sets further limits in addition to formal requirements, having reached the age of 18 and having the capacity of judgment. Within the limits of your right to dispose of your property, you, as a testator, may dispose of your assets in full or in part by testamentary disposition or by contract of succession, also known as contract of inheritance. So let's ask the question, what are the limits of your right to dispose of your property? First of all, ask yourself, does a contract of succession already exist? Without explicit reservations, a contract of inheritance boxes a testator in his right to dispose of his property. Second, you need to pay attention to statutory share. So if you are survived by issue or a spouse, you may dispose of that part of your property exceeding the statutory share of the survivor. Then third, what you should avoid are immoral or unlawful burdens or conditions, because they may render your disposition null and void. If contested, a testamentary disposition with such content may be declared invalid, and this is not what you want. So it may be permissible under certain circumstances to provide for a staggered payment to a beneficiary. However, to ask someone to live on the moon is considered impossible. And generous gifts to physicians may be immoral because their medical decision should not be influenced. And the same applies to other persons of trust, such as lawyers. Fourth, with respect to family foundations, please note that the establishment of fetail is no longer permitted. Then point 5, regarding contents, a testator is entitled to, in his disposition, to require a named heir as provisional heir to deliver the estate to a third party, a so-called remainderman. However, no such obligation may impose on the remainderman. And then, last point, if there is a homestead involved, always keep in mind that a federal law provides for the entitlement to the allocation of an agricultural business, a farm. The testator may not withdraw the right to allocation from a heir who is protected by a compulsory share and who wishes to manage the business himself and appears suitable for this purpose, in favor of a heir who does not wish to manage the business himself or does not appear suitable for this purpose, or in favor of an appointed heir. So now, knowing all this, it's up to you to consider what you will include in your will. Do it right, so that there are no unnecessary, expensive legal disputes. You want to have happy heirs. You don't want to leave angry heirs. And if you need help, please do not hesitate to contact me. I'm looking forward to hearing from you.